All right, settle down, class. Good morning, and pay strict attention. Welcome to today's intensive, exam-focused explainer. I'm your professor, and today we're dissecting one of the absolutely critical areas of the Sale of Goods Act 1930. Now, note this down immediately. Question 21, discuss rules regarding passing of property in goods. This exact question is a highly frequent standard 16-mark long-form prompt in your KSLU examinations. Look, this is the question that separates the average student from the gold medalist. You literally cannot afford to be vague here. Precision is the only way you're going to secure those marks. So let's jump right in.
Section 1, Introduction and General Rules. 2, Part I, Specific Goods. 3, Part 2, Unascertained Goods. 4, Landmark Case Law Breakdown. And 5, Importance and Conclusion. Listen to me carefully, students. A high-scoring answer script must always begin with a clear synopsis exactly like this. Don't just start writing long paragraphs. Show the KSLU evaluator the structural blueprint of your legal knowledge right on page 1. It tells the examiner you know exactly what you're doing.
Section 1, Introduction and General Rules. In your KSLU answer booklet, I want you to write this heading in bold block letters, dead center of the page. Structure is just as important as substance, so set it up properly.
Now, for the introduction to passing of property. The transfer of ownership in goods is an absolutely crucial aspect of a contract of sale. It determines who bears the risk and who has rights over the goods, and all of this is governed entirely by the Sale of Goods Act 1930. Put your pens down for a second and just listen to the dissection of this concept. Why do we even care about the passing of property? Well, because in commercial law, property simply means ownership. And the golden rule you must underline twice in your exam is this: risk follows ownership. The Latin maxim is res perit domino. If the goods are destroyed by a fire, whoever holds the ownership at that exact split second bears the financial loss, regardless of who has physical possession of the goods.
Moving to the general rule, Section 19 breakdown. Passing of property passes when parties intended to pass. The determining factors for intention are 1. Terms of contract, 2. Conduct of parties, and 3. Circumstances of case. Read this very carefully. Section 19 clearly dictates that intention is paramount. The law actually steps back and lets the buyer and seller decide when ownership shifts. But if their intention is ambiguous, how do we find it? Well, the courts will look at the contract's terms, the conduct of the parties, and the surrounding circumstances of the case. Here is a pro-exam tip for you. Draw a clear, structured list or table in your answer booklet exactly like this. Evaluators award maximum marks for neat, tabular representations of statutory tests. It just makes their job easier.
Part I, Specific Goods. This is where your answer most explicitly bifurcate. Don't mix up the rules. Remind yourselves and the examiner that the Act treats specific goods entirely differently from unascertained goods. Use this exact subheading to show that transition.
Specific goods. Goods identified and agreed upon at the time of contract. You absolutely must memorize this exact statutory phrasing. Do not paraphrase it. If I walk into a showroom and point to the exact blue car with a chassis number ending in 459, that is a specific good. It is identified and agreed upon right then and there. This definition is the very foundation for sections 20 through 22, which dictate when property passes for such goods.
Point 1. Specific goods in a deliverable state. Section 20. Property passes when the contract is made, and this applies even if payment or delivery is postponed. Let's really dissect Section 20. If the specific goods are ready to be handed over, meaning they're in a deliverable state, the mere stroke of the pen on the agreement transfers ownership, right at that very second. I am explicitly telling you, in your exam, draw a physical box around the phrase even if payment or delivery is postponed. So many students lose marks because they wrongly think you must pay to own. No! Under Section 20, the contract itself transfers the property and therefore it transfers the risk. Catch the examiner's eye with that box.
Now look at specific goods with pending actions, which covers Section 21 and Section 22. Under Section 21, if goods are not in a deliverable state, property passes when goods are put into a deliverable state and the buyer is informed. Under Section 22, if goods are to be weighed or measured, property passes when the required act is completed and the buyer has notice. Methodically observe the dual conditions here, class. Under Section 21, if the seller has to do something to make the goods deliverable, let's say polishing a wooden table, ownership does not pass until the polishing is done and the buyer is informed. Under Section 22, if the price depends on weighing the goods, ownership waits until they are weighed and the buyer has notice. In your exam, you must strictly write the word "and" in capital letters. It's a mandatory dual requirement. Completing the act is completely useless under the law if you don't actually notify the buyer.
Point 4. Sale on approval. Section 24. Condition 1. Buyer approves the goods. Condition 2. Buyer retains the goods beyond a reasonable time. This is your classic take it home and see if you like it scenario. Property obviously passes when the buyer explicitly says, "I'll keep it." But mark this stern warning for your legal understanding. Silence or unreasonable retention legally equates to approval. If you keep the goods for 6 months without rejecting them, Section 24 brings down the hammer. You own them now and you must pay for them.
Part 2. Unascertained goods. Announce this shift vividly in your answer script. Draw a line across the page if you have to. I'm warning you. Many students lose 6 to 8 marks right here because the rules shift entirely from the previous sections. The logic of specific goods just does not apply here.
Unascertained goods. Section 18. Goods not specifically identified at the time of contract. No property passes until goods are ascertained. This is an absolute negative mandate in the law. If I agree to sell you 100 bags of wheat from my go-down of 10,000 bags, we don't know which 100 bags are yours yet. So Section 18 strictly prohibits property from passing. I will loudly repeat this. Identification, or ascertainment, is the non-negotiable first step.
So how do we bridge this gap? Passing of property, Section 23. Step 1. Unconditional appropriation of goods. Step 2. Mutual consent of parties. Step 3. Delivery to carrier for transmission to buyer. Let's walk through this logical sequence. Once those 100 bags of wheat are identified, they must be unconditionally appropriated to the contract, meaning they are set aside and marked specifically for the buyer with mutual consent. Often, this happens the exact moment the seller hands those specific marked goods over to a transport carrier without reserving the right of disposal. Property only passes to the buyer when these specific statutory hurdles of Section 23 are strictly cleared.
Section 4, Landmark Case Law Breakdown. I demand absolute silence and attention for this section. If you want to secure a top-tier grade from the KSLU evaluator, mere theory is completely insufficient. Quoting these next 2 cases will instantly elevate your answer from average to outstanding.
First, Kersell the Timber Operators and Contractors Ltd. The ratio here. Property does not pass in unascertained goods until identification. In your exam, I strongly instruct you to write this case name in a separate boxed format dead center of the page. Now let's dissect the facts and the absolute relevance of this case. In Kersell, the seller agreed to sell all the merchantable timber in a Latvian forest that conformed to specific measurements. And these were to be cut over a period of 15 years. But before the trees were even cut, the Latvian government confiscated the entire forest. The massive legal question was, who owned the trees? The court's ratio decidendi was crystal clear. The property had not passed. Why? Because the goods were unascertained. The specific trees meeting the measurements had not yet been identified or cut down. This case is the ultimate, definitive proof of the Section 18 rule regarding unascertained goods. The risk remained entirely with the seller.
Second case, Underwood Ltd v. Bergcastle Brick and Cement Syndicate. Ratio, goods not in a deliverable state, therefore property does not pass. I direct you to definitely underline this case name. The facts are fascinating here. A heavy condensing engine was sold, but at the time of the contract, this massive engine was still bolted to a concrete bed in the seller's factory. It had to be detached, dismantled, and then loaded onto a train for the buyer. Well, while it was being loaded on the train, it was severely damaged. So, who bears the loss? The court ruled that the engine, while it was a specific good, was not in a deliverable state at the time of the contract. Detaching it from the concrete was a legally necessary act. Therefore, under Section 21, until it was safely detached and ready, property did not pass. The risk stayed firmly with the seller. You must explain this relevance explicitly to show your absolute mastery of Section 21.
Section 5. Importance and Conclusion. We now move to the final section of our lecture. Remember, a law student's answer without a conclusion is like a contract without consideration. It's incomplete. Every perfect 16-mark answer must have a definitive, commanding, concluding segment.
Importance of passing of property. It determines risk, because, as we know, risk follows ownership. It decides rights against third parties. And it's highly relevant in cases of insolvency. This is your strong academic summary right here.
By stating these points, you link back directly to your introduction, proving to the examiner that you have a fully cohesive 360-degree understanding of the statute. Think about it. If a buyer goes insolvent, whether the official receiver can claim the goods depends entirely on exactly when the property passed.
So I leave you with this. If specific goods follow clear statutory rules, but unascertained goods require appropriation, who ultimately bears the burden of absolute clarity before a loss occurs? This is a very provocative question. The burden lies on the drafters of the contract, and by extension, on you, the future lawyers of this country. As you prepare to enter the examination hall, deeply consider this fundamental relationship between clarity, ascertainment, and risk. Master the rules of intention, know your sections 18 to 24 by heart, box your case laws, and you'll achieve true excellence. Class dismissed.